So trademark rights are based on use in commerce, and there's a little bit of a carve out under the US laws that say even if you haven't started using a trademark yet, we want to give you an opportunity to start planning and building your business before you've actually launched a product or started selling a service. So this intent to use application, as the name implies, means that you haven't started doing anything that would technically allow you to register a trademark just yet, but you want to get in line at the USPTO to make sure that no one else jumps you for the name. You effectively start the examination process. The examiner starts looking for other marks for likelihood of confusion to determine whether or not your mark can be registered. But presuming that a notice of allowance is issued, you ultimately can come along after the fact and submit proof that you've started using the mark. Again, the only distinction there versus a standard, Section 1A classic trademark application is that the original application, the 1A filing form, just says, show me the proof up front, whereas the intent to use says, show me the proof after we've gone through the process of examination.
Protect your brand with Trademarkia. Register your trademark on Trademarkia.com.